Today we are present here to showcase the role play of a famous case on a very sensitive matter about pregnancy of a 26-week pregnant lady. The case is in between Mrs. X versus Union of India and ANR. In this case, the petitioner is Mrs. X and the respondent is Union of India. And the Chief Justice of this case are Honorable Justice D.Y. Chandrachud, Honorable Justice B.V. Nagaratna, Honorable Justice Seema Kohli. Here the petitioner is a married woman of 27 years. She and her husband have 2 children, the younger of which is about 1 year old. The present petitioner has been filed by the petitioner under Article 32 of the Constitution of India, praying inter alia for issuing directions to the respondents to permit the medical termination of her ongoing pregnancy under Section 3, subsection 2, clause B, subclause 1, and Section 3, subsection 3, and the 5 of MTP Act with Rule 3B of MTP Rules 2 in any government hospital, preferably at AIIMS, New Delhi, on a plea that she is neither physically, neither mentally, neither psychologically, nor financially prepared to continue with the unwanted. Some of the major issues of the case are whether a medical termination of pregnancy should be permitted when the pregnancy has exceeded the statutory limit of 24 weeks, whether the court has the jurisdiction to recall an earlier order, and what is the appropriate course of action given to the conflicting opinions and the new information regarding the fetus viability. Counsel on the behalf of the petitioner.
With the permission of the bench, I would like to proceed.
Counsel, proceed.
Much obliged. My lordship, I am here on behalf of the petitioner. My client is a married woman of 27 years. She and her husband have 2 children, the younger of which is about 1 year old. She filed the petition under Article 32 for direction to the respondent to permit a medical termination on her ongoing pregnancy. My client did not discover that she was pregnant until after 24 weeks of the pregnancy had elapsed because she had lactational ammonia. My client is a homemaker and her husband is a graduate working in a private company and has the responsibility of supporting his family. It is therefore unviable for the couple to feed one more mouth. Besides that, my client has severe depression issues for which she is going through medication.
She sought permission for a medical termination of the pregnancy, citing postpartum depression and her family's socio-economic circumstances. The court initially granted permission for the termination due to concerns about the petitioner's mental health, but later faced conflicting medical opinions and an email raising the concerns about the fetus viability.
Before proceeding for termination, we would request the following clarification from the Honorable Supreme Court. As the baby is currently viable, we will need a directive from the Supreme Court on whether a feticide can be done before termination. We perform this procedure for a fetus which has abnormal development, but generally not done in a normal fetus. A baby who is born preterm, also of such low birth weight, will have a long-staying intensive care unit with a high possibility of life risk. In such a scenario, directive needs to be given as to what is to be done with the baby. If the parents agree to keep the child, this will take a major physical, mental, emotional, and financial toll on the couple. If it is go for adoption, the process needs to be spelled out clearly as to it has to happen at least 8 weeks. We would be obliged if a directive on this is given by the Honorable Supreme Court to ease out the process. My client and her husband attempted to medically terminate the pregnancy at various hospitals, but that were unable to because of Medical Termination of Pregnancy Act 1971, read with the Medical Termination of Pregnancy Rule 2003, as amended in 2021. She therefore approached this court by invoking its writ jurisdiction. She sought permission for the medical termination of her pregnancy on the following grounds. A. She suffers from postpartum depression and her mental condition does not permit her to raise another child. B. Her husband is the only earning member of the family, and they already have two children to take care of. Additionally, they also have other family members who depend on them.
With the permission of the bench, I would like to proceed. Much obliged. So I am on the behalf of Attorney General of India. I would like to present some emphasis on reproductive autonomy with legal framework. The Council strongly assert that the Medical Termination of Pregnancy Act 1971 MTP Act is inherently pro-choice, serving as a legislative abandonment of the fundamental right to reproductive autonomy. Section 3, Clause 2, Subclause 2, Subclause B, and Section 5 of the MTP Act, the Council contends that the legislation meticulously strikes a delicate balance between empowering individuals with the right to make choice regarding their reproductive health and acknowledging the rights of the viable fetus.
Ms. Bharti, we realize that the termination will violate Section 3 and 5 of the Medical Termination Act.
My Lordship, as per Section 5 of the MTP Act, a pregnancy can be terminated even if it has lasted beyond 24 weeks. If the termination of such pregnancy is immediately necessary to save the life of a pregnant woman, and in this case, my client is suffering from postpartum psychosis.
Well, if life under Section 5 of the MPT Act was given the same interpretation as life under Article 21, it would defeat the purpose of Article 3 of the MPT Act. You are saying interpret life to mean life that is meaningful. So you want to give her this overriding power in the 37th week. That cannot be done.
My Lordship, in this case, the paramount consideration should be the mother's health and the will to give birth to the child. The first concern is the mother. The child's interest is secondary. Here, her choice to rights, privacy, dignity, and right to bodily integrity is hampered. The fetus is dependent on the mother and cannot be recognized as a different personality. Unless she wants to keep the child, her right to bodily autonomy or integrity cannot be beyond this act. The relief cannot be granted one-sided.
But the court have went through the AIIMS report. There is no immediate threat to the life of the mother, and this is not a case of the fetal abnormality, and it is if there is no danger to the mother and no abnormality to the fetus, the termination cannot be permitted beyond 24 weeks.
My Lordship, but the AIIMS report have also mentioned that the mother may have to be admitted and treated in case of worsening of symptoms. As earlier, I have mentioned my client is going through depression. She may hurt herself or her child in this case, as she is unwilling to give birth to the child. And as we know how much important it is for a mother to take care of herself and her fetus during this pregnancy period, she may not take proper care as she is unwilling. This may result in the child being born with physical and mental deformities.
But Ms. Bharti, the case has been reviewed by the medical board. The age of the baby is 25 weeks, 5 days. So as per the current status, the baby is viable and has a reasonable chance of survival. So in plain language, you are asking us to put an end to the child's life. In my opinion, every woman goes through a degree of postpartum depression. But do we really need 24 weeks to realize that?
My Lordship, my client is a patient of lactational ammonia. In such cases, women who are breastfeeding does not menstruate. Therefore, she didn't realize that the absence of menstruation is an indication of pregnancy. Once she came to know that she was pregnant, she immediately wanted to abort the baby. She already went through C-section delivery twice before. I would request the court to consider my plea.
The court has recognized one of the grounds of the basis of which is the pregnancy may be permitted to be terminated, in which is continuing of the pregnancy could be seriously affected the mental health of the woman. As per this result, the woman is already suffering from the mental health issue. We have to recognize the fact that the expression mental health has a broader context.
But my lordship, the AIIMS report had confirmed that the fetus is healthy and viable, and there is no immediate threat to the child or the mother due to ongoing medication.
But do you think the interest of the mother who already have two children and would deliver to the third child within a year of the delivering the second? must be given the preference.
But my lordship, they should have taken appropriate precaution, and we can't neglect the fact that the fetus is viable and has a reasonable chance of survival. We can't just stop a heartbeat. The life of the child is as important as that of the mother.
Well, don't you think that the decision to carry the pregnancy to its full term or terminate it is firmly rooted in the right to bodily autonomy of the pregnant woman?
My lordship, what's about the right of the unborn child? It has a reasonable chance of survival and it has already been 25 weeks, 5 days. The woman only have to carry the pregnancy for few more weeks so that the child is not born with physical and mental deformities, and if she doesn't want to keep the child, then the state may take care of the child after birth.
Now, the court will announce the judgment.
After hearing all the arguments and going through all the evidences, the court had decided that a medical termination of pregnancy should not be permitted as it had crossed the statutory limit of 24 weeks and no substantial fetal abnormalities were detected, and we respect the petitioner's decision not to issue a direction to stop the fetus heart, and we direct that the delivery would be conducted by AIIMS at the appropriate time with the union government covering all the medical expenses. The government would also facilitate the adoption process if the petitioner decides to give the child up for adoption. The court is adjourned.
So now, after hearing all the judgments given by the Honorable Justice, the conclusion of this case has come to the court carefully considered the legal framework and the circumstances, emphasizing the welfare of the child and the petitioner's wishes while providing support to the petitioner in a sensitive and a challenging situation.